Two families, same situation, completely different outcomes. Both families had aging parents in their late 70s. Both parents had been healthy for years, independent, mentally sharp, still driving, still managing their own finances. Both families had been meaning to sit down with an attorney and get the paperwork sorted. Both families kept putting it off. There was never a perfect time. It felt morbid. The parents resisted. Something always came up. Then, within 3 months of each other, both parents had a health event. One had a stroke. One fell and sustained a traumatic brain injury. Both were hospitalized. Both were temporarily unable to communicate or make decisions for themselves. For one family, the next several weeks were still frightening, but they were navigable. The adult children could access their parents' medical records, talk to the doctors, authorize decisions, manage the bills, keep the mortgage current. They knew their parents' wishes. They had the documents that said so. The crisis was real, but the response was organized. For the other family, the next several weeks were a legal catastrophe layered on top of a medical one. They could not get information from the hospital. They could not access the bank account. They could not make decisions. They hired an attorney mid-crisis to begin a court process that took 2 months and cost over $8,000 to grant them the authority they needed. And even then, they were not entirely sure they were honoring what their parent would have wanted because it had never been written down. Two families, same situation. The only difference was 5 documents. Today we are going to walk through the 5 foundational legal documents every parent needs before a health crisis, what each one does, what happens without it, who needs to be named in it, and how to get it done. We are going to cover the order that matters, the timing that matters, and the conversations that have to happen for any of this to actually work. This is the video to share with your parent. This is the video to watch before you think you need it. This content is for educational purposes only. It is not legal, financial, or medical advice. For your specific situation, consult a certified elder law attorney. You can find one at nala.org. Let's begin. Why most families wait too long before we get into the documents themselves? Let's look at the landscape. Because the gap between how common this problem is and how avoidable it is should be the most motivating thing in this video. According to Pew Research data from late 2025, only 32% of American adults have a will. Only 31% have a living will or advance directive. Among adults in their 60s, the exact demographic whose parents are most likely to be in or approaching a health crisis right now, only 46% have a will and 44% have an advance directive. Put another way, more than half of Americans in their 60s, people who are often simultaneously managing aging parents and beginning to think about their own futures, have not completed the most basic planning documents. The reasons are consistent across surveys. People say they are waiting for a health concern before they feel it is necessary. They find the topic uncomfortable. They assume they have more time. They think their situation is too simple to need professional help or too complicated to sort out without a fight. None of these reasons change what happens when the document is missing and the crisis arrives. Let's go through what you actually need, in the order you actually need it. Document 1. The durable financial power of attorney. This is the most immediately actionable document on the list, and in many ways the most important one to get right. A durable financial power of attorney is a written document in which one person, the principal, authorizes another person, called the agent or attorney in fact, to manage their financial affairs. The word durable means the document remains in effect even if the principal becomes incapacitated. Without that word, if it is just a power of attorney, not a durable one, it becomes void the moment the person can no longer make their own decisions. That is the exact moment you need it most. The powers granted in a durable financial POA typically include managing bank accounts, paying bills, filing taxes, managing investments, handling real estate transactions, managing retirement accounts, and conducting financial dealings with government agencies, including Social Security and the Veterans Administration. Without this document, a child who is trying to pay their parents' mortgage, manage their accounts, or make any financial decision on their parents' behalf has no legal authority to do so. Banks will refuse access. Utility companies will not accept instructions. Financial institutions cannot take direction from someone who is not the named account holder. The only alternative is a court-supervised process, conservatorship, that is slower, more expensive, and less flexible than a properly drafted POA. A few things matter enormously in how this document is drafted. First, it should be drafted by an elder law attorney. not filled out from a template. Generic forms exist and are better than nothing, but they may not be honored by certain financial institutions, may not include the specific powers needed for your parent's situation, and may not comply with the specific requirements of your state. Second, naming the right agent is more important than the document itself. The agent must be someone with the integrity, financial competence, and genuine commitment to act in the principal's best interests, not their own. As we covered in an earlier video, POA agent abuse is one of the most common forms of elder financial exploitation. Choosing carefully matters enormously. Third, consider whether oversight provisions belong in the document. A requirement that the agent report to a second family member, a limit on certain types of transactions, or a co-agent arrangement where two people must agree before money moves. Fourth, the document needs to be stored where it can be found. A signed, durable POA that cannot be located in a crisis is functionally useless. The agent should have a copy. A trusted family member should know where the original is. Document 2. The Healthcare Power of Attorney, Healthcare Proxy. This document answers a different question than the financial POA, not who manages the money, but who makes medical decisions. A healthcare power of attorney, also called a healthcare proxy in some states, designates a specific person to make medical decisions on the principal's behalf when the principal cannot communicate or make decisions for themselves. That includes decisions about treatment, surgery, hospitalization, discharge planning, care settings, and end-of-life interventions. Without this document, hospitals operate under surrogate decision-making laws that create a default hierarchy, typically spouse, then adult children, then other relatives. This sounds workable until you encounter real-world complications. If adult children disagree, the surrogate law does not break the tie. If there is no spouse and multiple children have different views about treatment, the hospital is in an impossible position. If the patient has a domestic partner who is not legally married to them, that partner may have no authority at all under a default surrogate hierarchy. A healthcare proxy designates one specific person, with backup designees in case the first is unavailable. It removes ambiguity. It gives the medical team a clear point of contact with legal authority to make decisions. And it ensures that the person making those decisions is someone the patient trusts, not whoever happens to be available or whoever speaks the loudest. The healthcare proxy and the financial POA are separate documents that should both be in place. They can name the same person as agent or different people depending on who in the family is best suited for each role. Some families designate one child who handles finances and a different child who handles medical decisions, particularly when one child lives closer, has a healthcare background, or has a stronger relationship with the parent's medical team. Document 3. The Advance Directive, Living Will. If the healthcare proxy answers who makes decisions, the advance directive answers what decisions should be made. An advance directive, often called a living will, is a written statement of the patient's own preferences about medical treatment. It typically covers the use of life-sustaining treatment if there is no reasonable expectation of recovery, mechanical ventilation, artificial nutrition and hydration, resuscitation, pain management, organ donation, and other end-of-life interventions. This document matters most in situations where the patient cannot communicate and the family is being asked by the medical team to make a decision with no guidance from the patient themselves. That is a devastating position to be in. Adult children who have not had the conversation with their parent are left guessing, or, in the worst cases, making a decision they will carry for the rest of their lives without knowing whether they honored what their parent truly wanted. An advance directive does not take away anyone's hope. It does not mean a patient gives up on recovery. It means that if the situation reaches a specific threshold, if the medical team determines there is no reasonable prospect of meaningful recovery, the patient's own previously stated wishes govern what happens next, rather than a family's paralyzed guesswork in the worst moment of their lives. Some states and healthcare systems also use a document called a POLST form, Physician's Orders for Life-Sustaining Treatment, or in some states, MOLST. Unlike an advance directive, which is a patient-created expression of preferences, a POLST is a medical order signed by a physician that becomes actionable immediately. It travels with a patient across care settings and can be honored by emergency medical personnel. For patients with serious illness, advanced age, or frailty, a POLST may be the more appropriate tool alongside the advance directive. An elder law attorney or the primary care physician can advise on whether a POLST is appropriate for your parent's situation. Document 4. The HIPAA Authorization, This is the document most families have never heard of, and it is the one that causes some of the most immediate and infuriating problems when it is missing. HIPAA, the Health Insurance Portability and Accountability Act, is a federal law that protects the privacy of patients' medical information. Under HIPAA, healthcare providers cannot share a patient's medical records, test results, diagnoses, or treatment information with anyone the patient has not specifically authorized. This applies even to adult children, even to spouses in some circumstances, even in an emergency. A HIPAA authorization is a signed document in which the patient explicitly names specific people who are permitted to receive their medical information from healthcare providers. It does not give those people the authority to make decisions. That is the healthcare proxy's job. But it does give them the right to information. Without it, an adult child calling a hospital to ask about their parent's condition or contacting a primary care physician to discuss a diagnosis may be told that the provider legally cannot share that information with them. The HIPAA authorization is often the simplest document on this list to execute. It does not require an attorney, does not require notarization in most cases, and can often be obtained directly from a healthcare provider or downloaded from state resources. But it needs to be signed while the parent has capacity to sign it. After incapacity, the window has closed. One additional note: a healthcare power of attorney may be sufficient in many states to satisfy HIPAA requirements for the named healthcare agent. The two documents overlap, but having a separate HIPAA authorization covering additional family members who should receive information, even if they are not the primary decision maker, closes gaps that the healthcare proxy alone may not cover. Document 5. The will and what it does not do. Every list of essential elder planning documents includes the will, and for good reason. A will is a legal document that expresses how a person wants their assets distributed after death, names an executor to manage the estate, and can name guardians for any dependents. Without a will, state intestacy laws determine who inherits. Those laws follow a specific formula, typically spouse first, then children in equal shares, that may not reflect what the parent actually wanted. A child who was estranged may inherit equally with a child who provided years of care. A domestic partner who was not married may receive nothing. A specific item of sentimental value may go somewhere the parent never intended. But here is what the will does not do, and this is as important as understanding what it does. A will does not control assets that have designated beneficiaries. Retirement accounts, IRAs, 401ks, 403bs pass by beneficiary designation, regardless of what the will says. Life insurance passes by beneficiary designation. Bank accounts with a pay-on-death designation pass directly to the named beneficiary. These assets skip the will entirely and skip probate. This means that a will, standing alone, may be addressing only a fraction of a parent's actual estate. And if beneficiary designations are outdated, naming an ex-spouse, a deceased person, or no one at all, those assets can end up somewhere the parent never intended or stuck in a legal process the family did not anticipate. A proper review of the estate picture, working with an elder law attorney, looks at both the will and all beneficiary designations together, not separately. The order and the timing. Here is how these documents should be sequenced in practical terms. The most urgent are the durable financial POA and the healthcare proxy. These are the documents that prevent a legal crisis during a medical emergency. If a parent has any health vulnerability, a chronic condition, a recent health event, a diagnosis, these two documents should be created before anything else on this list. The advance directive follows immediately behind. The conversation about end-of-life wishes is harder than the document itself, but once it has happened, the advance directive is a relatively straightforward record of what was decided. The HIPAA authorization can be added at the same time as the healthcare proxy, typically during the same attorney visit or appointment. It takes very little time to complete. The will and beneficiary designations require a fuller review of the estate picture. They should be completed, but they are not emergency documents in the way the first three are. A parent who has a will from 10 years ago should have it reviewed, but a parent who has no healthcare proxy and no durable POA should get those first. And all of these documents should be reviewed, not just created once and filed away. Whenever there is a significant life change, a divorce, a death in the family, a major health diagnosis, a move to a different state, a significant change in assets, the conversation. All of these documents require capacity to create. That is the fundamental constraint that makes timing so important. Once a parent can no longer understand the nature of the document they are signing, the window is closed. Most parents are not resistant to this conversation because they do not care about their family. They are resistant because the conversation feels like a concession, like admitting that they are declining, that they are a burden, that their children are starting to make decisions for them. The reframe that tends to work is this: the documents are an expression of control, not a surrender of it. By creating a healthcare proxy and an advance directive, a parent is ensuring that their wishes, not a court's default, not a hospital's protocol, not whoever among the children speaks loudest, govern what happens to them. The documents do not take power away from them, they preserve it. The conversation also works better in a low-stakes, unhurried moment, not during a health event, not during a family conflict, at a kitchen table on a Sunday afternoon with no agenda, starting with something like, "I want to make sure I know what you'd want if something happened, not because I think something is going to happen, but because I want to get it right," and then listening. Before introducing the attorney, before talking about the forms, listening first. What to do this week. If you are watching this as an adult child whose parent does not yet have these documents, start with a conversation this week. Use what you learned here. Share this video if it helps frame the topic. Then call an elder law attorney and schedule a consultation. You can find a certified elder law attorney at navigable.org. If you are watching this as a parent yourself, this is the video to act on before something requires your family to act on it without you. The conversation with an elder law attorney takes a few hours. The documents take a few weeks to prepare. The protection they provide lasts for the rest of your life. And if you are already in a crisis, a parent is hospitalized, documents are missing, the immediate situation needs managing, skip to the action. Call an elder law attorney today. Many states have emergency provisions for creating or finalizing documents even in a medical setting if capacity still exists. The window may still be open. Next video teaser. We have now covered the full legal foundation, the power of attorney, the healthcare proxy, the advance directive, the HIPAA authorization, and the will. But there is a version of this picture that bypasses several of these documents entirely, and in some situations, it is a better tool than all of them combined. It is called a revocable living trust. Most families have heard the term. Very few understand what it actually does, when it is worth the cost, and when it is not. Next video. The Revocable Living Trust explained: who it is for, what it costs, and why it matters for families managing aging parents and their own planning at the same time. We will see you there. Disclaimer, spoken. Everything in this video is for educational purposes only. It is not legal, financial, or medical advice. Rules vary by state and change regularly. Document requirements, naming conventions, and execution formalities differ across jurisdictions. For your specific situation, please consult a certified elder law attorney at navigable.org and a qualified financial or legal professional.